Yes, there is no mention. Item 1. Yes, Mr. Das.
Thank you, Dr. Here, Approved High Court. Against an order or better, Family Court number 1 at Guwahati. The Family Court in the divorce case, my lord, granted divorce and also allowed alimony of rupees 20 lakh and the respondent man. Plus,
Yes.
we have come for scrutiny of the order, my lord, regarding the alimony, my lord. Divorce has been granted, marriage has been dissolved by a decree of divorce under section 13, my lord. But the alimony portion, according to us, my lord, is not based on proper appreciation of the my lord. My lord, during pendency of the divorce case, my lord, the respondent filed one application under section 24 of the Enumerated Act claiming as interim maintenance fund. Maintenance and maintenance.
Yes.
Thereafter, she filed another petition on section 25 of the Enumerated Act claiming alimony of rupees 20 lakhs.
Yes.
Further, my lord, during pendency of that case, she filed another case under section 125 CRPC in the same court, my lord, claiming maintenance amounts of rupees 20,000 per month. My lord, the learned family court disposed of both the cases on 29/9/23, my lord. In the maintenance case, the learned tribunal, the learned family court granted maintenance of rupees 10,000 per month, my lord, on the date of the filing of the petition, my lord. And in the divorce case, the learned family court granted 20 lakhs of
Permanent alimony.
Further, my lord, under section 24 of Enumerated Act petition, the respondent was given 2,000 contingent materials. My lord, we have submitted exception liabilities. And also we have reduced evidence regarding all income and the income of the respondent also, my lord. But the learned family court gave the maintenance of 10 lakhs plus 2,000 of the 10,000 per month plus 2,000 of evidence given in the divorce case. And that too from the date of the petition. That means that case was filed by in 2015. Then for 7 years, the area comes to about 11 lakhs, 10 to 11 lakhs. And that 10 to 11 lakhs is added to 20 lakhs.
No, the best interesting part is that with that kind of income, you maintain a Harley Davidson.
Not just one, your lordships, he has 7 bikes.
Seven, okay.
And it is there on statement in his own, when he was cross-examined, he has admitted that he has 7, not Indian bikes, foreign bikes. And apart from that, he drives a Creta. And yet, since August last year, since August 2023, that rupees 2,000 has also not been forthcoming, your lordships.
Because I am yet to touch one.
We can only dream about such things. Anyways.
No, dream you can.
We can
It's the only question of touching that.
The respondent has got one ultimate government shop.
But that the trial court says couldn't be proved. The trial court says that except for photographs that couldn't be proved. Her income could not be proved. That she has an income can't be proved. No, but since it's an appeal, we'll have to admit it. But how much you will deposit as alimony?
Lord,
1/3 you deposit at the, for the time being, 7.5 lakh.
They have not brought on record the other order, which my learned friend has stated to your lordships just now, that there was another simultaneous order passed in the maintenance case, wherein, as per the latest judgment of the Honorable Apex Court in Rajneesh versus Neha, learned family court has deemed it fit to grant an interim maintenance of 10,000 rupees, which will continue only till the payment of the permanent alimony. The moment he pays us the permanent alimony, that order will negate itself. And that, as per the Supreme Court directions, it naturally has to be from the date of filing of the petition. So there's nothing wrong with that, but they have not brought that order on record, your lordships. And they have not.
That is
made any
okay.
payments.
If that is not here,
What-
we enforce it.
Lordships. And
Mm.
and in fact, I have already filed an.
Just a
executive-
moment. Let
Lord-
Mr.
Lord-
Das complete.
Lord-
Under section 155, the court has the discretion to grant maintenance from the date of the filing of the petition or from the date of the orderment. But in this case, what happened? The petitioner, the respondent filed the maintenance case under section 125, but that case was dismissed twice, my lord, for non-prosecution. He was not diligent. She filed the case, remained absent for several months. It was dismissed. After a few months, she again came and revived the case. Again, my lord, after revival also, she remained absent and she was dismissed for second time. So whether the justification of granting maintenance from the date of the filing of the petition, that is to be seen, my lord. So we pray your lordship, my lord, that the hearing that may be given, in detail we shall argue the case. And today it should be.
But some alimony you have to deposit. You deposit 1/3, make it 7 lakh rupees. You deposit as a condition for grant of stay.
My friend is second, 520 is.
2 lakh doesn't make a difference. It is 1/3 we are making. This is Chaudhary, make it 7 lakh.
Manage with that, my lord.
How can that be a problem? Lordships, you have a chance?
We will give you 6 weeks time to make the deposit.
That would be a little harsh on me, Your Lordship. I'm absolutely, the reason why the Honorable Court has taken all things into consideration, it is not that I'm not trying to work, Your Lordship. Unfortunately, I only hold a graduate degree and I'm not able to find employment anywhere. So I have managed to open a small shop somewhere where I earn a very meager amount, about 400-500 rupees a day, which is less than what a daily wage earner earns. And so therefore, it becomes very difficult for me to survive, Your Lordship. I was a housewife when married to him for almost 11 years. And
Recently, you read in the newspapers, $74 million salary, and he says that you read it, $74 million salary, and that also is difficult for him to manage.
In fact, that 2,000 rupees, the amount for that 2,000 rupees, they first filed a review before the Honorable Family Court. Then
Whatever we
filed
got,
a
but
complaint.
whatever we got.
It was only.
Now you're getting nothing. Now you'll be getting at least.
Kindly make it 3 weeks, Your Lordship, because he has the resources. And since July 2023, he has not made a single payment at all, Your Lordship, because the matter was in the final stages of hearing. And he has not heard. And may I also point out that not just the bikes which Your Lordships have considered, in his statements which were annexed before the Honorable Family Court, which naturally have not been annexed here, he's also purchased Air Jordans, which I don't know whether Your Lordships are aware, they are shoes which are to the tune of 55,000 each pair. So if you can afford to buy those kind of shoes, 2 pairs simultaneously, and it's by his bank statement, Your Lordships. It is
No,
by
you
his
see-
bank statement. So.
No,
everything
you
is
see,
on record.
that's okay. But
He
we
can
can't,
pay it within 3 weeks, Your Lordships.
but we
Why-
can't assess the financial capacity with those things.
No, they're all his FDs, everything was on record, Your Lordship, because. as per
You know,
the
my
Supreme
one
Court
of my sorry, one of my experiences, Mr. Mishra is sitting behind. Don't stand up, just he's sitting behind. I was a very poor man. Similar dispute, alimony, no income, and I did not have the courage to move the division bench. So I requested Mr. Mishra, and then he consented to do it pro bono. And as soon as he stood up, the court said that we now understand what is his paying capacity. Don't have to say anything. Deposit, appeal dismissed. And that is at the motion stage. Correct. So.
What can I say? Doctors will not make it 6 weeks. I only pray for that. It's a small.
And it was really pro bono, really pro bono, but that is.
His stature, perhaps.
Yeah, like that.
Good. Mr. B.C. Das, learned counsel for the appellant, and Ms. R.S. Chaudhary, learned counsel for the respondent. Next paragraph. By filing this matrimonial appeal under section 28 within bracket 3 of the Hindu Marriage Act, the appellant the divorce has been granted.
Yes, sir.
The appellant, who is the divorced husband of the respondent, has assailed the judgment and order dated 29/9/2023, page 1, passed by so and so and so and so, granting payment alimony or rupees 20 lakh in favor of the respondent. Which was done in exercise of jurisdiction under section 13 within bracket 1 within bracket small I dash small a bracket closed of the Hindu Marriage Act. Next paragraph, the appeal is admitted for hearing. Call for the records. Let a formal notice be issued on the respondent without requiring the appellant to take any steps, as the respondent has entered an appearance through learned counsel. List after 4 weeks awaiting receipt of LCR. There's no IA file. IA is not there.
No, I am.
But you are required to file an IA.
Yeah, doctors are only prior agreement for stay of the operation of the for the time, so they expect those payment of permanent elimination.
No, I understand, but normally with an appeal, order 4105 is separately filed. Then you add the heard both sides on the prayer for interim relief. Like having regard to the description of miscellaneous assets which is stated to be owned by the appellant. The court is inclined to stay the enforcement of the order dated 29, judgment and order dated 29/9/2023, passed by the Principal Judge, Family Court 3, Kamrup Metro, Guwahati, in FC Civil Case number 264 of 2015, subject to deposit of a cost of deposit of a sum of rupees 7 lakh for the registry of the court within a period of 6 weeks.
May kindly make it. That is
No,
my
then
only preference,
we
Lordship.
must give some realistic time. We must give some realistic time.
And 4 weeks, Your Lordships, perhaps. This appeal was also filed in December.
Is Mr. Chaudhary is
Judgment
pressing
was
for,
in September.
Mr. Chaudhary is pressing for 5 lakh.
Lordship, that is a little, which is very harsh on me. And in any case, the other part of the order, the 10,000 rupees, that is also what they have not been
No,
compliant.
that, for
I
that,
filed an execution.
for that
already
we'll
over
have to
this.
do it.
I've already filed an execution.
Make it 5 weeks then. 5 weeks.
Lordships,
Disposal of grounds,
Huh?
after that, will
Not this permission, I can say, the conduct of the respondent has not been taken before by the judge. It is essential. Because the conduct, the divorce was granted. At the instance of the.
No, you see, in a family dispute, conduct is something when people start fighting, they will start from 1965. Correct. In 1965, you did not give me what you call fully baked roti. Can be a sign of dispute even now. After 60 years of togetherness, they will say in 1965 you did not give me good food.
it
Therefore, we
is
are starting the
regular
trouble.
with us, Lordships.
You see, no. You see, there is no unfounded allegation. One of the allegation is that you have a relationship with another woman. So there are certain materials when both sides fight. Many things come out of the closet. We are not assessing each and every conduct of parties, because you see, you shows that for the purpose of conduct, there can be a reduction in the there can be a reduction in the quantum, because it's here the law is that you will give the same status to the wife which you have. So you can't help it. We'll hear it at that point of time, but not for the interim order.
Divorce has been granted on the grounds of cruelty.
No, we'll hear it on merit. Mr. Chaudhary, if you are ready, we can hear it on merit, but you'll have to wait till 2 o'clock. There's a parted matter going on. At 2 o'clock, if you want, we'll hear it on merit and dispose it off.
Your Lordships.
LCR will not require, we'll dispense with.
I have the entire LCR for Your Lordship's perusal.
But we are not hearing the entire matter, but we are ready to do so.
Disposable income of the new young things has not been taken before. Only the gross income has been taken before. Disposable income, in fact, the disposable income, net income of.
If he's
No,
talking
no,
about-
Yeah, that's great.
no. You see, Mr. Chaudhary, please understand us. You can very well argue it on merit, but not for the purpose of interim relief. Interim relief, we are reducing it by 1/3. Because if we make that assessment, if what Mrs. Chaudhary says is correct, that you have 7 what you call motorcycles. No, it's not that. We are not, you see, I'm not going into the merit.
My submission, Your Lordship,
So-
was his own statement.
No, that's okay. But you see, when we have those kind of assessments made, I told you, we have our limitations so far as we are concerned. Speaking for myself in the bench, I can say I have not touched it, the Harley Davidson till date. Correct. And therefore, I'm not saying that I have not touched it, therefore I am biased against you, not that. But the question is that I couldn't afford it and therefore I couldn't touch it. Correct.
And that is a vintage motor. that is
No, I don't know that.
Paragraph
I-
42 of the judgment.
I don't know that.
Paragraph 41 and
No,
42.
it's okay. We are not doing it. Make it 5 weeks then.
5 weeks.
Deposit of so within 5 weeks.
Lordship, if in case it is not submitted, I have the right to come back, even if the LCR is not received, I may be allowed to come back to this honorable court. By,
You see, Mrs. Chaudhary, it's a civil proceeding. If you see, if I have stayed it and they don't make a deposit, then what? You read the recent judgments of Supreme Court after 21, contempt does not lie. You will have to go back to the trial court and have the decree enforced. subject to condition. Can be discharged, Mrs. R. Chaudhary, counsel for the.
RS.
Instance. Give it us. Give it us.
Can we ask?
No, it's not in the list. He's right.
Oh.
If it is not in the list, it will not be uploaded in the system. CS will not accept it. Four weeks.
Fixed date.
I'm not fixing a date right now. Make a mention because we are waiting the LCR.
Much of. Rajat has to deposit it before the registry or.
Before the
by
registry.
The registry.
Mr. Chaudhary, you will deposit it here or before the trial court?
Or he has the bank account also, your lordships, because that's what he was normally doing, he was transferring. So that can also be done, we can produce a statement that he has actually deposited. Provided he's.
You give the
provided
bank-
he's,
okay. You say deposit in the bank account of the respondent. So Mrs. Chaudhary, the counsel for the respondent shall provide to the learned counsel for the appellant the bank bank account particulars so as to enable the deposit to be made to the bank account directly.
Be privileged.
Yes, item 2. Just a moment. Is 302. Okay. That's right. Counsel for the appellant. And Mr. S.H. Baral and APP for the state. Appellant is section 374 2 CRPC. Page number 1. Appeal is admitted for hearing, call for the records. Issue notice returnable in 4 weeks. Make it after 6 weeks and give a date. The appellant, no steps is required to be taken in respect of respondent number 1 as notice is accepted by the London APP. The appellant shall take steps for service of notice on respondent number 2 by registered post with AD as well as by usual process, which shall be served through the jurisdictional magistrate. From the concerned court. In charge of the process shall ensure that the service report is returned to the court after service. Next para list on so and so.
22 March.
This interlocutory application, the same shall be considered on visit of LCR. Yeah, notice.
But already my lord, LCR has come, my lord, in another appeal.
It has come.
Lordship, case number 2, appeal file, my lord.
Acha,
Appeal number
just-
469, 2023.
Okay, then don't call for the LCR. When you write, it is submitted by the learned counsel for the appellant that the LCR is received by the registry in connection with
Criminal appeal number 469. 2023.
of 2023. So therefore, press requisition need not be sent. Full stop. The learned counsel for the appellant. Let's list after 6 weeks or list on so and so, along with the records of criminal appeal number so and so. I also you issue notice. It will be taken up on service of notice on respondent to.
Item 3,
Yeah, the receipt of LCR now. Wait, wait. This is 302?
Yes.
Okay. Just. Same as a 302. Mr. B. Barwa, counsel for the appellant. Notice on respondent number 2. The call for the LCR above. List start on after 6 weeks,
22 March.
22/3/2024. Yes, Mr. Bhagwati.
Metropolitan appeal and section 25 petition. On the
What
last
happened
hearing,
to-
The matter was referred before the High Court Conciliation Center, and he agreed to pay 15 lakhs. This is a question of now 15 lakhs, how much?
Make it 1 rupees more.
I will try your.
If you have agreed to 15 lakh rupees,
No,
make it,
15 lakhs he has agreed to pay, but we have not agreed.
you are not agreed.
He-
Okay.
Wife has not agreed. So it is between 15 lakhs to 20 lakhs, how much?
Answer is simple. If you waive your fees, then it will be 15 lakh.
All right, in that case, I will, let the matter be fixed for another day. I will convey the matter, take instruction from that
Ah.
client.
If he is, if miserly person like Mr. Jha has agreed to 15, I think you should waive off your fees and then. it will-
He's a Malit Mal, his client is also Malit Mal. So for me, divorced wife without any income.
Make
I'll try
a, make
also.
a necessary difference, settle it. Okay. Mr. B.K. Bhagwati, Learned Counsel for the appellant. Sorry, applicant, appellant. And Mr. N. Jha, Learned Counsel for the respondent, have submitted that the there are further attempts. No, the users say they would both consult with their with the respective parties for finding out if whether there is further scope of settlement as the matter relates to quantum of permanent alimony only. Full stop. It is made clear that if the parties do not arrive at a negotiated settlement within the next date, the matter would be heard on merit. We grant you 2 weeks time to negotiate. After that,
I think 1.5 months may be given. All right, I have no problem. 1.5.
no, because if the parties they don't want to settle and then unnecessary delay.
Yeah, I agree for the 15 lakhs you're also. Right, for this, 1.5.
Okay. 6 weeks. Give date after 6 weeks.
22nd March.
22nd March. Okay. Yes, item 5.
In the IL also have great for subscription of sentence in that of paper.
Pardon me?
In the IL also.
You're paying for bail. Huh.
Yes, sir. Otherwise notices were issued lordship when appeal was admitted and NCI was called for lordship. So if I may say lordship, in the meantime, the sentence is suspended and in the AP inside lordship, they have filed a written objection to the lordship.
We have filed our application lordship.
Objection has been filed.
Lordship, let's just have to come up for hearing.
No, he's pressing for interim, this bail.
In this case, lordship, even though the sections are 376 lordship, the prima facie lordship, it appears that the mens rea is not there, lordship.
Pardon me?
This is the case, even though the penal section is 376 lordship, what has happened that there's allegation of rape is there, lordship, and there's two accused persons. One allegedly has made the video and the other committed the crime, lordship. But the thing is that lordship, admittedly, lordship, there is no mens rea attached to it, lordship, because statements of the victim can be seen because they were coming.
He is convicted of POXO. Mens rea is not required to be proved.
It's lordship, but at this stage, lordship, because he's already behind bar for a long time. lordship.
But there is evidence, convincing evidence for,
So that has been challenged, that we are challenging that lordship. So lordship would kindly see the objection.
no, because you see the participation of two people, that is something which is very disturbing. One is holding the girl and the other is raping her.
No, that is not the case. One is allegedly he was video recording. And
I don't know, evidence of PW4, just see PW4.
As per that objection lordship, in PW4, here she along with her mother was returning home. However, the victim stayed back with her to watch the function of Sukhabad. At about 4 a.m., they saw that the victims had seniorly she came running towards their house and was crying. On being asked, the victim told that the accused person had strangulated her, dragged her, kicked her, and made her fall in the drain of the tea estate, took her photos and threatened to kill her if she complained to the police. She also stated that on being asked, the victim told them that accused A1 raped her and accused A2 was holding her hand. And the victim's clothes were covered with mud hurts. That was also not recovered with regard to that lordship.
The accused number one raped her and the accused number two was holding her hands.
That these were statements of PW4, but if with regard to the other lordship, that actually contradicts it. Lordship. If lordship would see would read the judgment, it will be very clear, lordship.
Yes.
If I may just read the judgment.
No, because she is not an eyewitness. She said what was stated to her by her girl. She is not an eyewitness. Had PW4 been an eyewitness, she would not have permitted this rape for the first time.
Yeah.
Correct. So therefore, she is not there. She says that the girl came back running, and after that, the girl told her what has happened. And she is a minor. And that part of the evidence has not been shaken.
If I may, with regard to only with respect to the suspension of sentence and grant of bail, lordship. It is a prima facie lordship, there are contradictions in the statements made by the witnesses. All the statements are contradictory to each other. Yeah.
Lordship would see the medical report. Just a minute, Lordship.
No, we are not inclined to grant bail.
Manoj, if I may just point out two things, Lordship.
Pardon me?
If I may point out two things, Lordship.
Yes.
First of all, Lordship, in this case, Lordship, there was no seizure of the plot.
No?
No seizure of the plot, Lordship. The process of the victim, number one, which is has a major role in this case, because she was pushed to the Nala, according to the story of the prosecution. Number one. Number two, Lordship, as per the medical report, there is no injury or nothing, Lordship. And number three, Lordship, that can also be considered because there is no injury. And there is no statement from the medical officer that there was a case of rape as per the medical report. Number two, Lordship. Number three, Lordship, the greatest contradiction is that as per the statement of the victim, Lordship, one was doing a video and all the statements of the other witnesses say that one was holding the hand. So whether someone was holding the hand or someone was doing the video, that is itself a question which is doubtful, Lordship. Now the Lalit court below has used the principle of preponderance of probabilities, Lordship, not your reasonable doubt, Lordship. If your Lordship, you kindly see the entire judgment, there's every statement of the witnesses are contradictory to each other, Lordship.
No, there was no eyewitness. So the question of there being a contradictory evidence will not arise. Even the statement of the victim is enough to.
That I absolutely agree, Lordship, but there is a contradiction between the statement of the victim itself and also the corroborating witnesses, Lordship.
No, not much, which will dent the evidence because 164 statement and the statement recorded in the court are almost similar.
Lordship, this medical report, Lordship, we kindly see once, Lordship.
I've seen that. I am holding it. It's at page 12. I am holding it.
That there is no sign of rape, Lordship.
No, it doesn't say so.
Not intact. That is all.
It was not intact.
Yes.
Evidence of struggle and stains not detected. That's what it says.
Not intact.
You see, please understand this. This is a girl of 14 years. She was raped at 1:30 in the night. Next day morning at 2:30, she is taken for medical. And it can be normal in this, what do you call, in this area, file under section 389 IPC, CRPC, comma, the applicant who is convicted of commission of offense punishable under section 6 of the POCSO Act 2012 and section 376 capital DA IPC. And sentenced to undergo what is the sentence?
Rigorous imprisonment for 20 years and pay a fine of 3,000 in default. Simple imprisonment.
Where you are reading that
I also pay
page?
or Lordship at page number 44.
44. Oh, sentencing was separately done. Oh, okay, that's right.
Right.
Okay. For 20 years. So rigorous imprisonment for 20 years and to pay fine of rupees 3,000 with default stipulation. This is for Vidhan Tanti. No, both. No, no, this is one application for one accused or two accused? Both the accused, okay. Oh, sorry, both the applicants, Mr. Vinson. Next. At the trial stage, he was at jail all throughout. Next one. The here for suspension of sentence and for bail is opposed by the London APP. And in this regard, she has referred to the written objection filed by the state on 28/2/2023. And she has referred to the evidence of the six PWs examined by the prosecution, including the doctor and the IO. And it is submitted that the victim was enjoying a cultural function at Tiloi, TILOI, Gramya, GRAMYA, Bazaar. And on the pretext of taking the minor girl away from the place, they lured her for going to visit a nearby shop, and thereafter taking advantage of isolation, the applicants had pushed her into a drain and committed rape on her. So it is submitted that in connection with the offense of rape, the evidence is to the effect that while one of the applicants had, and as per his instructions, the staff of the cinema hall had lodged an FIR, and it is quite possible that
Noise also not exist.
as the cinema hall is no longer existing, it's quite possible that the informant may not be available. Next, be that as it may, as the court has already issued a notice on respondent number 2, we are inclined to direct the learned APP to to transmit or download the orders of this court to the Golaghat officer in charge of Golaghat police station, who would make an inquiry as to the as to whether the respondent number 2, namely Sri Ananda Bodhakur, page 2 was a son of so and so, resident of so and so, is still available to report about his current address, comma, if known. Stop. The officer in charge of Golaghat Police Station shall transmit the information to the court through the office of the public prosecutor Assam at Guwahati High Court. Next para, the learned APP is not required. You say a list on how much time? 3 weeks time would be okay. Give a date after 3 weeks.
Lordship.
Fourth of March.
Awaiting report from the officer in charge of Golaghat Police Station.
The hard ballot after coming. And set to 9. And lordship also has to be, a reminder has to be issued.
Okay. In the you also write in the appeal that let a reminder for the LCR be also issued. In this IA, you write the IA shall be taken up on receipt of LCR and service and report of service on respondent 2.
Item 7.
Yes, visuals. Lordship, this ISN file for condemnation of delay of approximately 2 days in filing the connected criminal.
Yes. For Mr. U. Chaudhary, counsel for the applicant, who appears as a legal aid counsel. By this, also had Ms. S.H. Boral and APP for the state. Next, by this application under Section 5 of the Limitation Act, on the applicant who is in jail.
He's in.
Hmm?
He's in.
He is in jail. Has prayed for condoning the delay of 42 days beyond the period of limitation in filing the connected appeal against the judgment and order dated 11/9/2023, passed by so page 1, huh? Is in description of so. Next, the learned counsel for the learned legal aid counsel has submitted that some time was consumed in the matter being reported to the Guwahati High Court Legal Services Committee through the Secretary DLSA Jorhat. And by the time the connected appeal was filed, there was an inadvertent delay of 42 days in filing the appeal. Next, although the learned the APP has opposed the prayer for bail opposed the prayer for condoning the delay. But having regard to the fact that the connected appeal is moved by the Guwahati High Court Legal Aid Committee through a Legal Aid Council. And further taking note of the fact that the applicant is in jail and that there was a delay in communications and providing of the relevant papers to the learned legal aid council, the court is of the considered opinion that issuance of notice on this application to the state can be dispensed with. As the learned APP has already heard on the point. First of, in view of the explanation given by the applicant, the court is inclined to accept the same said explanation as good and sufficient cause, which has caused delay in the filing of the connected appeal. Next, accordingly, the delay of 42 days in filing of the connected appeal stands condoned. Next, this application stands allowed. Next, the registry shall now register the connected appeal and list the same in admission column.
Okay.
You provide a copy to her memo appeal. We'll take a break and come back, and then we'll resume that part. Notes. Just a moment, the notes are left behind. Yes, please start. We'll pick it up.
So yesterday, I referred Exhibit 5 series. And started with list of the name of officer. And it is alleged that Sinam Uday Singh
Hmm.
is listed at serial number 5. I've shown it to your lordship that I don't know this person's name doesn't tally with me. This is number 1. Apart from the fact that this has come from an email executed by an officer from CFS Chandigarh without any certification under 65 P4. So otherwise also it cannot go into it. Then
That was PW 53.
5.
PW 5.
PW5 M. Bhaskar. He is the one who is a senior scientific officer. And at that point of time, he was junior scientific officer in CFS in Chandigarh. So he has taken it out, he has admitted the printout taken, but there is no certification. So this will not otherwise also go into evidence. The last exhibit, my lord, that I will point out is exhibit 18.
Which page was his evidence?
His evidence, PW.
Compilation 1.
Yes. Page 34. Compilation.
Compilation 3. Okay. Was
Very well.
No, this is something in a lighter tone. You see, come to paragraph, page 34, para 2, 3.
Yeah.
Related to physics, computer science, I have examined about 600 cases.
Yes.
So you see, in 600 cases, no fault is found. Why should I find one here?
Correct. I read it yesterday. Yes. At page 36, he says one line. Tenth, ninth line. The attachment, namely list of officers in 5 pages.
Pardon me?
10th line, third paragraph, page 36.
Yes, it contains an attachment.
Yes, attachment, namely officers list. Page 5, exhibit 5(1) is my signature on exhibit 5.
Attachment, namely officer list in 5 pages.
Yes. Yes.
Yes.
Now, this he has taken out, and cost of repetition, I'm saying, there is no certificate, this will not go in evidence. Now, the last one is 18. 18 is also exhibited by this PW5. And I've shown it yesterday, you should note it also at page 37.
Yes.
Page 37, first paragraph, last 3 lines. Exhibit 18 is the email dated 11/6/2010 from so-and-so, containing attachment under subject biodata, and these are my signatures. So these emails are also printout was taken in Chandigarh, exhibited by an officer of the Chandigarh, no certification.
Yes.
Now, 18/7, there are some photographs. 18/7, there are some photographs. I'll not take your lordship because it's been wasted of time. If my learned friend comes out with something, I'll come back. But it contains my lord photographs. Now, they allege that it is me. It is me. Then they say we took the simple photograph and sent it to the expert, PW44. And he said both tally. In the examination 313, I was not even asked a question, this is your photograph. The question is rather the other way around, that they have taken the sample and it has tallied what you have said. I have no knowledge. So naturally, it was not taken. And the sample photographs are not before your lordship, unless he produces. We have checked all. It's not there. So 2 things I will say. Number 1, this is an email which is not admissible. This I'm saying time and again. I don't want to repeat, but I'm doing similar matters, so there will be repeating. And the third is the photographs. And photographs, they say there was sample thing. Nowhere the sample photograph is there.
Can you just take out that paragraph
Yes, yes.
of the evidence?
Yes.
Sample photographs.
First, I will show you compilation 1. Compilation 1. And we come to compilation 1. At page 7. 7.
7, there is ABC,
Yes, that's,
page 7.
yes, 7. First, your lordship will come to 7. 18, yeah, 18/7 is at page 7. So I'm not here. Is it? I'm not here, it's written 18/7. Says, I'm not here. That is not their allegation.
No, I'm not following you. Page 7.
Page 7. you know, you
Yes,
got.
yes,
There is officers list.
yes.
Now, I'm not here.
Okay.
Then, this is the email which they receive and they say, I'm Kader. I can put on an, saying suppose I'm there. I can put on an army dress and take my photograph. So it will make me a member of UNLF. Especially when that email is not admissible in evidence. Now, if the lordship will see 7 again, and another exhibit 18.7 at page 7B. So there are 2 exhibits, number is 18.7. One I have shown, the other one is at page 7B. At serial number 27, isn't it? The name which is there in the officers list. Lieutenant Colonel Sinap Wangleng Bhuneshwar is mentioned.
Yes.
Now a sample photo was taken. The sample photograph is not on record. If it is there, if she produces, then I reserve my right to reply. Then I will take a lordship to who has exhibited where is the expert report? That is by PW 44, which I've already referred, but on this also he is the person who has given report. So at this stage, this is my submission. Now, 2 questions were asked regarding this. Well, today I want to finish, so I will just give you lordship the equal. Question number 16, 313. This your lordship will find at page 777. Page 777, paper book 4. Question and answer is not in our compilation. Part 1, Volume 4. Three statement as such starts from 773 of this person. And the two questions that were asked, one is 16, another is 32.
Page 777.
Page 777 is question number 16. And question number 32 is 783. 783.
Question number?
32. At page 783. Now, my lord, one thing I'll point out. Your lordship has seen it, handwriting expert opinion. There is one handwriting in a paper which is said to have been forged. Then the sample handwriting also is sent. Sample handwriting is taken before some witnesses from the person or even by the order of the magistrate. And then it is question document will be sent with the sample document for tally. So here they have sent a sample photograph. How it is taken, who has taken, where is the sample photograph is not known. So that my learned friend will come and then I will reply. This will bring my note an end to this with 263. Criminal Appeal 263 of 2016.
Yes.
Not in.
Absolutely no evidence. And Learned Single has discussed in 3 paragraphs. This particular paragraph 46, 47, and 69. Paragraph 46, 47, and 69. In 69, my lord, he has discussed about the dossier of NSA. 77. On NSA dossier.
Yes.
But as I submitted earlier, NSA dossier cannot be an evidence for anything. And the difference between preventive detention and punitive detention, I have a decision which I would like to praise. It's 1975, 3 SCC 198.
AIR
This is also 1975,
1975.
3 SCC 198. Paragraph 19, your lordship will find at page 135, compilation 2. I'm relying on paragraph 19, which my lords will find at 136, page 136, compilation 2.
Paragraph?
19. 136, page 136. The essential concept of preventive detention is the detention of a person is not to punish him for something he has done, but to prevent him from doing it. The basis of the detention is the satisfaction of the executive of a reasonable probability of the likelihood of detainee acting in the manner similar to his past act while preventing him by detention for doing the same. The criminal conviction, on the other hand, is for an act already done, which can only be possible by a trial and legal evidence. There is no parallel between the prosecution in a court of law and detention under the act. One is punitive action and the other is a preventive act. No one can, in no case, a person is punished on the proof of his guilt. In one case, a person is punished on proof of his guilt and the standard of proof is beyond reasonable doubt. Whereas in preventive detention, a man is prevented from doing something which is necessary for the reasons mentioned in section 3 of the prevention act to prevent. So these are altogether different things. So dossier of is made by SP, relied upon by the deputy commissioner or the government to pass an order under section 3 of the to detain. That cannot be an evidence in a case, my lord, which is a criminal case. And therefore, my submission would be that paragraph 69, my lord, is liable to be rejected as a whole, because it's based on anything. Now, in view of this, my lord, my prayer would be that no case is made out against accused number 8. 11. Accused number 11. Number 11, and his life. Is liable to be imputed. Well, I come to the next case, that is 265, Criminal Appeal 265 of 2016. This case, my lord, is verbatim. We will cover the argument in accused number 8 will cover this case. Just few things that I'll point out to your lordship.
W. Noren Singh.
W. Noren Singh. The evidence against him is only email, no oral evidence, no video, like AA. Here also no video.
No oral evidence, only email.
Only like 8. One of the evidence, the emails that have been relied on, 115/176.
115 oblique.
176. 176. This, my lord, will find at page 79 of compilation 1. There is nothing this is regarding arrest in Guwahati. Can't make out anything, my lord. Only thing in the middle, just below 3, D/NY. The names are mentioned, were picked up from parental house of Thoiba White at Silchar, and so they arrest only by the police. There is nothing else. And this is not original, these are photocopies, so we don't know who has sent it, who has received it, when it was sent. And the original, of course, it was in Manipuri, so we don't know. Then the next email relied upon is Exhibit 5 series, the name of the officer at page 1 of compilation 1. As stated yesterday. If your lordship will turn to page 2. These are attachments to email. And those emails are mentioned at page 1 of compilation 1. I placed it yesterday, your lordship in Google.
Yes.
But his name, according to the prosecution, appears in the column measurement. Your lordship has already seen Lieutenant Colonel serial number 5. That was accused number 8. At page 11, at page 2. One is the email, and this is the attachment.
Yes.
Having compilation 1.
Yes. Which page?
Page 1.
Page 1 we have seen. Page 1 we have seen.
No, page
List
2.
of officers attached.
Yes, page 2. So, in case of accused 11, I had shown your lordship number 5.
Yes.
Now he is major in that column, serial number 8. Serial number 8. Volume 1. Well, kindly see the chart sheet, which is part one, volume one.
Wahingbam Toiva.
Yes. It is why Hangdong, Toiba, Elas, so many things. He is, if your lordship will see here only at paper book, charge framing is 4, same name is there in the chart sheet also.
Okay.
There, your lordship will kindly come to 4. Yes.
Compilation 4. Yes.
He is at serial number 4.
Page number
Page 31.
31.
30.
Serial number 4.
Serial number 4 is Wayampam Noran Singh. Alas Thoiba. 8. The name does not tally. There is no evidence which shows that both are the same person.
It is photo.
In paragraph 47, the learned trial judge has referred as 18:4 exhibit which contains his photograph. We have seen it is not there, but it is at 18:14. 18 in bracket 14.
You are losing touch on literature.
Yeah.
You are losing touch on literature.
Yes.
Shakespeare said, "What is in the name after all?"
That's right. No.
You could call Rose. You could call. You could name Rose with any other name. Gives the same fragrance.
So this is also photograph and said by submission will be similar. No sample photograph, number one. No question asked, is it your photograph? Or if two persons are there, the first natural thing will be for a my lord trial judge to compare himself whether they are same person.
No, that can't be done because it substitutes personal knowledge. So it can't be done.
It's not, if I remember section 75 of the Evidence Act, the handwriting can be compared by the court. It can be compared. Let me see if my memory serves me. It is 75 or somewhere, but it is there. That for.
No, that can be done, but it can't be substitute.
No, it's not, no, I'm not saying substitute, there has to be. But I'm saying additionally, he could have said, yes, I have seen the photo and I'm seeing the person, and both are same.
Because opinion, that will come with the 47.
Yes, not 75, I think I'm not.
No, 47 is opinion is to handwriting.
No, I was saying 75, but.
Oh, no,
it's
75 is documents.
Yes, that's right.
Hmm.
So, but there is somewhere, if I cannot find it now.
No, it's okay.
I'll show it to your
No,
lordship.
it's okay.
73, if your lordship will see. Hmm. 73 says comparison of signature, writing or seal with other admitted or proved.
Or proved.
Yes, in order to ascertain whether a signature, writing or seal is that of a person by whom it purports to have been written or made, any signature, writing or seal admitted or proof to the satisfaction of the court to have been written, made of that person may be compared with one which is to be proved along with that signature, writing or seal had not been produced or proved for any purpose. The court may direct any person present in the court to write any words or figures for the purpose of enabling court to compare the words or figures written with any word or figures alleged to have been written by such person. So the power is there.
Yes.
The power. But suppose I'm saying there is a photograph of a say film star, and the prosecution alleged he is the person. Will trial judge not see and oh no, it can't be that? So it will be an additional satisfying factor for the court to reach the satisfaction that he is the person. I'm only saying that.
I'll tell you why. You have this universals. You have these universals with you.
you and me.
Universal
Yes,
book.
yes,
Now, please open that provision again.
All right,
I'll,
73.
I'll tell you why.
Yes.
There are comments,
Yes.
editorial comments.
Yes.
Now you come to the third one.
Yes.
It is not open for the court to compare. That is our judgment.
Yes. Or, yes. Or signature of its own service of expert are liable to be taken for this purpose.
It's not open for the court.
All that
No,
happens-
not that. You're right when you are saying it, but
No, no.
this is an authority where it says, I don't know whether it says, any Supreme Court has given a decisive rule.
The entire burden lies on the prosecution to prove it. I'm just saying for the satisfaction of the court.
No, correct.
I'm only saying that
uh-huh.
because my lord, suppose a horse is lost and a donkey is placed before it. An expert says yes, definitely it will be the duty of the court to see what are you talking about in this kind of a court. I'm saying all this satisfaction.
Right.
And in earlier time, if your lordships will remember, if a session judge is started taking down the evidence and he's transferred, and another session judge comes, he'll have to begin again. And that is how that practice was discontinued. And the reason was that when the session judge is taking down the evidence, he will note the facial expression of the witness. Because after all, it is said face is the index of mind. But that has been dispensed with, because with the volume of cases and the number of judges, it's impossible in this country to do that. But it used to be. It used to be the law. So, my lord, this is, as I said, exactly covered by my argument, which I have made in respect of accused 11. There are no other evidence. And the only thing I'll give two questions, similar questions, which have been asked regarding photograph, is question number 18 at page 732, paper book 4. Part 1, volume 4. And next is question number 32 at page 737, paper book 4. Oh, I'm reading. I'll be able to. So, my lord, I have placed 263, criminal appeal 263 and 265. These two I have completed. Accused number 8 and accused number 11.
हाथ में जो है और जो दो
Now I will start by of criminal appeal 291. It will take some time.
This
This
becomes a reading material for us in a different position. Because this question 732, those questions
Yes.
appear to be a question wrongly framed.
Naturally.
So we'll have to give it to the Judicial Academy. Because you see, rightly said, answer is also right. Question is that so and so were sent for comparative matching. What do you want to say? See, I am not aware. The question should have been whether they have identified you. What do you have to say? Then this is a academic material.
This 291 is very interesting case. Now take it up 291. Let's say this man is harassed.
291.
291.
Braja Bandhu Singh. Braja Bandhu Singh.
It's very unfortunate, my lord, but I must tell your lordship, he is on his deathbed, 4th stage cancer. He's in Chennai. This is the information that my junior got it.
Braja Bridhu.
Brother Bindu Singh. He was an executive member, it is alleged, of AGIS, that is Association of Extensive Growers Innovative Services. AEGIS. He has been convicted under 2 sections. Section 20 and Section 21, both of UAP.
In this previous W. Noren Singh,
Yes,
he was convicted under
20, 18, and 121.
121 capital A.
20 UAP, 18 of UAP, and 121A of Indian Penal.
And he is only 20 and 21.
21, 20 and 21. Now, 20 also, it's all based on the emails. So I will produce that. My lord, the main charge against is against AEGIS. And the main charge is that AEGIS is a frontal company set up by UNFA, by
UNF.
by UNLF. It's a front company set up and administered by UNLF. That is the allegation. And it is alleged that 3 accused persons were managing the AEGIS. One is 24. There are accused number 23 and 25. The main allegation was against AEGIS. The NIA knew very well that AEGIS is a society registered under Society Registration Act 1860, because they have relied upon Exhibit 48, which is rules and regulations of AEGIS. AEGIS. I'll start with that rules and regulations. It is one. Your lordship may have a compilation 1. Actually, this was attached with with an application for opening the account. And that your lordship will see at page 8. 8 of compilation 1. Lordship,
Something like you bury a grenade or arms near a tree and they grow fast. Innovative,
well,
innovative
what
growers.
the very ingenious method they have for investigation. They go to the chartered accountant, seize all the papers. They go to the cooperative bank, they seize all the papers and then they level the issue. From there, ignoring their statement made, they have just pick up the part of the statement. And unfortunately, the trial court also did the same. Very unfortunate. Now, this is at 8 is exhibit 48, I'm placing. This is a letter issued to branch manager, Urban Cooperative Bank Limited, so and so. I, the undersigned, beg to state that we, the members association for extensive grower innovation service, would like to open current joint account in your esteemed bank with immediate effect. So along with that, enclosed documents, along with, and he the accused number, whom is he? Accused number 23. Now, your lordship will see the rules and regulations. These are, of course, resolution and first place resolution. Following is the extract of resolution passed unanimously in the executive meeting of the association for so at office premises at 11 a.m. with Braja Bidhu Singh as president in the chair. This is 2004. Because I will show my lord from the 313 statement that Braja Bidhu said that after 2005, he has no connection because he's a sick person, he got cancer. And he's still fighting with the cancer. So I'll just resolve unanimously that current bank account for Association for Growers Innovative Service be opened at Imphal Cooperative Bank Limited, Imphal, in an early. The proposed current account will be operated jointly by the president, secretary, and treasurer of the organization. Further resolved that check of the cash should be withdrawn by 2 of the above mentioned 3 signatories. Resolved that secretary be assigned to submit necessary documents to the concerned bank to expedite the matter. Then rules and regulations. These are all part of the application. My lord, at page 10.
Yes,
At page 10, serial number 4, which my lord can kindly see.
yes,
The date of commencement of the society shall be 1985. So it was, and that time it was registered at the 1860 Act, Society Registration Act. That should may come back.
let's complete this part.
So this society was created in 1985. And 19, if your lordship will come to rule 19 at page 30. This is composition of governing body, managing committee, and election of members. the management of the society shall rest in a governing body, managing committee to be elected by the general body. The following shall be composition of the governing body. Governing body shall consist of not less than 7, but not more than 11. Any bona fide member of the society who was admitted 3 months prior to the date of election may be elected to be a member of the governing body or managing committee. Members of the managing committee shall elect from themselves one president, one vice president, one secretary, and one assistant secretary, and a treasurer. And then casual vacancies. What I'm saying, the entire power rests in the governing body. And governing body can elect the president, vice president, secretary, assistant secretary, and one treasurer. Lordship, I will take your lordships to the Society Registration Act 1860. Your lordship will get that compilation number 4. Compilation number 4. Compilation number 4, page 36. Your lordship, is Society Registration Act 1860. This is the first page. Then the relevant will be 5. Then I'll come to 1. Now 5, your lordship will get at page 39. Property of the society, how vested? The property movable or immovable belonging to a society registered under this act, if not vested in trustee, shall be deemed to be vested for the time being in the governing body of such society, and in all proceedings, civil, criminal, may be described as property of the governing body of such society for their proper title. So this is basic. Then part 1, if your lordship will see, 38. Society formed by memorandum of association and registration. Any 7 or more persons associated for any literary, scientific, or charitable purpose, or for any purpose as is described under section 20 of the Act, may by subscribing their name to a memorandum of association and filing the same with the registrar of joint stock, form themselves into a society under this Act. Now, if the allegation is that AEGIS is a frontal society of UNLF, then investigation should have been who had the 7 persons or more who formed this society in 1985. This could have been found out by going to the registrar. Nothing was done. And why I'm saying it, that I will reveal later. There is a provision in CRPC which provides how a company or a society or a firm shall be prosecuted. And then I'll say that this is a mistrial insofar as the present accused is concerned.
You would say that there is no corporeal punishment. It will
No,
only
the corporate is responsible. And the governing body, the property vests in governing body. Who am I? I'm a paid employee working under them. And you said this is a frontal company because you have got few emails which are not even admissible. There is no certificate. These emails were taken by PW 44, CP Gangwar at Chandigarh. He has not even given the certificate. And your lordship has seen it was taken out from CD, where it was downloaded in NIA office and sent to Chandigarh. So I will place 305, section 305 of CRPC, and I'll also place, there is another Society Registration Act. Manipur has made its own Society Registration Act in in 1989. And one section, section 32, that the society registered under the 1860s society will be deemed to be registered under this society, 89 society. I'll place these two things. The lordships are sitting at 210.
And
I'll come.
we'll have to rise at 3:30.
I'll come. The lordship will not imagine how happy I will be to complete this. This is a photo I'm carrying since
I am
2011.
reminded of uh, particular day in the court number 1. I think Justice UL Bhatt was presiding. And one of the lawyers, I won't name, after having argued a writ petition, the court commented was that the white collar jobs are better than white collar or blue collar. What is the opposite of black color?
White.
So black color, we are doing the white color matters better. Here we'll have to say it reverse. Instead of white collar, you can turn coat and become a black collar.
Justice Sanjeev Singh was in Chief Justice when I took up this matter, and all bails were granted, only on these grounds. Bail were granted. Number one, what is contained in the image, who will prove it, he will write to be that scene, all this. And another was, of course, admissibility. On these two, he is straight very released. Now, after that, my lord, I got involved. I will get rid of it. This is your lordship, that the prosecution was aware that EAVIS is a society registered with Corporate Society Act, and because they have existed publicly, which is rules and regulation of the society, and which discloses that it was established in 1985. I also placed before your lordship that under Rule 19, the management and control of the AEGIC rests in the governing body, which may consist of 7 or 11 members. Then I placed before your lordship section 5, which says that property of the cooperative society shall vest in, if not always already vested in the trust, it will vest in the governing body. That is section 5 of Society Registration Act 1860. I also placed before your lordship section 1, how the society is formed. So any 7 or more persons can file a memorandum of association and convert themselves into society. That is what section 1 of Society Registration Act 1860 says. So now I'll place my lord, the Manipur Society Registration Act 1989, which is compilation 2 at page 137. I'll say just one section. Similar provision as that of 1860. Section 32, the lordship will find at page 149. One 49 of compilation 2.
Yes.
First one I'll place, Society Registration Act 1860 in its application to state of Manipur is hereby repealed. So they repealed 1860 Society Registration Act, under which this was registered, my lord, in 1985. Then number 2 says, subsection 2 says, any society registered in any place within the state of Manipur under the Society Registration Act 1860 shall be deemed to have registered under this act, and its principal officer shall be deemed to be registered office of the society. So while you are not concerned with it, I'm not. So they never to try to find out who is the principal officer. And thus they caught hold of 3 persons, use number 23, 24, and 25. And my lord submitted charge sheet against them. Now, before I go to section 305 of CRPC, which provides a separate procedure for prosecuting these society, firm, or company, I'll place my lord the charge sheet, just a few lines from the charge sheet, and then charge. Part 1, volume 1.
But this is again interesting. Society Registration Act is a central act. How can the state repeal it?
So far as Manipur is concerned,
No, but
in its application, they have done it, that's a different issue altogether. That's
No,
a
but-
different issue. Because the lordship is aware, these areas, the law made by the federal government will not automatically apply. Because it is started with, if you remember, your lordship will remember, the first was Garo Hills Act 1869, which was repealed by Scheduled District Act 1874. All these I have referred in many cases. And then came Government of India Act 1915. Then Government of India Act 1935. There is a history of the application of laws. So I don't know, and I have not gone into that aspect. You're not concerned here whether they.
No, it's okay.
For my purpose, not required, I did not go into. But those are the decisions, my lord, relevant on the point. There are many decisions. My lord, I'll just take a few lines I will place, my lord, from part 1, volume 1, charge sheet. Your lordship may turn to 108, page 108. This is part 1, volume 1. This is supplementary charge sheet. It starts from actually page 95. Supplementary charge sheet dated May. Paragraph 17.4. In order to build its financial assets out of extorted money, UNLF, as part of its strategy and cover, invested money of different projects, companies, including Association for Extensive Grower Innovation Service, AEGIS. Then says AEGIS is Fruit Processing Unit, a front company of UNLF. Established, financed and administered by UNLF. Investigation has revealed that in pursuance of the larger conspiracy, UNLF has made substantial investment in AEGIS. Accused Gomi Singh, A23, was secretary, accused Brother Vidhu Singh, A24, the present appellant before your lordship, was an executive member, and accused I. Ibomcha Singh, A25, was treasurer of AEGC till 10/1/2012. These three accused persons, 23, 24, and 25, were persons managing the whole affair of AEGIS, including investment of extorted money of ULFA into it. So this is, my lord, the basic allegation in the charge sheet. And there's not an iota of evidence to show this. It's not easy. They'll have to show that I have knowledge, number one. Number two, how this AEGIS is formed, when it was formed, who are the initial members who have submitted memorandum of association before the joint registrar as required under section 1 of the society registration in 1860. Then whom the property vests and who is the in charge of this society. It's managing, it's governing body, not any individual, as I have shown from section 19 of the Act. Now I'll take your lordship to section 305 of the Code of Criminal Procedure. It provides altogether a separate mechanism because the allegation is against AEGC. AEGIS. I forgot to place the charge, but let me place this on that. After that, I'll place the charge. Your lordship will kindly come to 305, procedure when corporation or a registered society is an accused. in this section, corporation means an incorporated company or other body corporate and includes a society registered under the Society Registration Act 1860. So AEGIS is included under 305. Where a corporation is accused person or one of the accused person in any inquiry or trial, it may appoint a representative for the purpose of inquiry or trial, and such appointment need not be under the seal of the corporation. Then there are, these are the procedures, special procedure. None was followed. They say that AEGC is not an accused, but the allegations are against AEGC. And you say AEGC is the front company of UNLF and we are managing the affairs. So we are servants. The property doesn't vest in us. If it is invested into AEGIC, it vests in the governing body if it is already not vested in the trust. As per section 5, I have placed your lordship, that provision. Now they have brought us in. The property doesn't vest in us. It comes to AEGC account.
because we had a query. Like. Definition section of unlawful activities prevention. EC, person. Person includes company, firm, so and so. Therefore, even if this front company is not investigated, but the person involved, and if he can,
Sorry, I'm sorry to say, this doesn't mean. It means wherever the person is, a company can be a person. Society can be a person. That is the expression meaning.
yes.
It is not a substitute
No,
for.
no, 6 says any agency, office or branch owned or controlled by any person falling within the so and so. So, therefore, the question I am asking is that let us assume for the time being that this Aegis was not proceeded with.
Yes.
But one of its constituent.
Say employee.
Employee, okay. One of its employees there, but if it can be shown that he was involved in in any activity
Yes.
which would lead either to a proceeds of terrorism or it would be collection for the benefit of the organization. Why person alone?
Individual can, I'm not saying individual cannot be charged. Individual can be charged. But society, basic allegation is against the society. And suppose a person who is an employee, whether he has control over the society or it is controlled by the governing body. It proceeds by taking the resolution. Your Lordship has seen the resolution for opening the account. And this society receives major grant from the Ministry of Foods and other ministry, Government of India, major funds. Its accounts were audited by Reserve Bank of India. It's in the evidence. It's in the evidence. Now, my lord, suppose it's a body corporate, whether it is society or it's a company. It's a legal person, a company.
Juristic person.
Now the company works through, doesn't have leg and limbs. It works through human agency. Therefore, if company has committed a crime, if the allegation is against the company can choose who will represent. And naturally, if it is provided that the company's affairs are governed by the board of directors, it will go to board of directors and board of directors will choose. And the responsible person will go to jail. And fine, of course, can be realized from the entity. But entity cannot be sent to jail. So what I'm trying to say before your lordship, the allegation is not that ULFA has given, UNLF has given me money. There is no allegation that they have extorted money and gave it to accused number 24 and I am managing affair. That is not the allegation. If that was the allegation, it would have been different thing altogether.
Okay.
That's my point. Now, my lord, if I will take your lordship 2 minutes with the charge. The lordship will remember there is one decision which has not been rescinded till date, which was given in 1936. Everybody knows. Nazir Ahmed.
Nazir Ahmed.
Nazir Ahmed is a case of 164. How 164 statement is to be recorded. And that, my lord, is being followed even till today. And not only in criminal case, in every case. And the rule is that if an act provides to do something a certain way, a particular way, it can be done only that way or not at all. Now, Nazir Ahmed is these 2 lines, so everywhere it is used. So what I'm trying to say is, if there is a procedure and the allegation is against a registered society, why have you left him? Why have you left the cooperative society and you have got hold of some employees? And the very unfortunate thing is that the person who conducted these trial, he should be responsible. Actually, he should be held if we cannot, well, punish him legally, well, take out some method to punish. He's a person.
No,
Well,
we have a law for that. We have a law for that also. Because then the accused can always come back for malicious prosecution.
That we will not be beneficial. Well, we'll come to page 34, compilation 4. That's the charge. There is separate charge for these two persons. They were also charged with 120B, 120A, and then 17, 18, but they have been convicted under 20 and 21. So I'll read these only two charges at page 35, the last two charges. That you being member of terrorist organization involved in terrorist act as mentioned in foregoing head of fifth head, that 60 where everybody is executed, thereby committed an offense punishable under section 20. And this is only based on emails. So it will be my argument in number 6. I will cover this. Section 20. The learned junior points out the mistake. The mistake he points out in the charge which was named and I have placed in respect of all other persons. The word mentioned is as mentioned in the 5th head. If the Lordship remembers.
There's
Because
no
there was
first.
a separate 5th head. Here also it says 5th head. There is no 5th head. 5th head is
This is the only head.
It's only head.
Charges with two heads, in fact. If he's
That is different. Here, I think, yes, page 32, can you see page 32? Your Lordship may come to 33. That you being member of terrorist organization involved in the terrorist act as mentioned in the foregoing head of charge in 5th head. Your Lordship seen it. Now, your Lordship will
fifth head is in page 32.
refers to 32. The 5th head is there. You being member of United Nations Liberation Front, a terrorist organization did terrorist act by using grenade, explosive, etc., etc. Now, this 5th head is not there in this at page 34.
Okay. Charge is defective.
Yes. It's like
Charge
my
is
lord,
defective.
it's like my lord, one there was a boy who was copying from a book. So he wrote, as you have read in the previous chapter. So now 21, 20 will be covered by this thing, my argument in case of Rakesh, accused number 6. 21, that you being members of terrorist organization involved in AEGIS and knowingly hold property derived or obtained from commission of terrorist act and acquired through terrorist funds and thereby committed offense under section 20. At the outset, there is not even an iota of evidence to even remotely might not suggest that such act has been done. There is absolutely no evidence on the part, and I'll please.
Just a moment. You were referring to, previous to this, you were referring to page 136. That was of?
136, I referred, that was from part 1, volume 1.
Part 1, volume 1. Okay.
Part 1, that is also charged. But for your Lordship's convenience, we have brought both the charges or all charges in compilation. Now, as I submitted, there's not an iota of evidence. Now, from where they have tried to show, my lord, link this accused person, accused number 24, is from some email. Some of the documents which were seized from the Imphal Cooperative Bank and some from my CA's office. These are the evidence on record to show that I have used extorted. I'll first place, my lord, the documents which are not emails, but which have been relied upon. The first document, my lord, the lordship may have compilation one because most of the documents are in compilation one. The first document is Exhibit 48. This I have already placed. This was the application for opening of bank account. This I just placed.
Yes.
Then resolution of the governing body and the rules and regulations. This I have already.
Yes.
So this is 48. Not again repeat.
48 is page 8.
48 starts from page 8. And then it ends at my lord with rules and regulation. It ends at
19.
And this has been exhibited by the PW 23, who is the general manager of the Imphal Cooperative Bank. I'll place his statement. Then your lordship may turn to page 20. The next page. This is followed a statement of account of AEGIS from Cooperative Bank with effect from 8/7/2004 to 16/8/2005. There is nothing for me to show. This is an open thing. It's in a statement account from the bank. This will not show that either AEGS or anybody has committed any crime. Unless they refer to some entry and say, oh, this is the money that you have received. So this is also no evidence in my humble submission. Then my lord will come to page 22. 22. This is a
Sanction letter.
letter from the bank by which 50 lakhs was sanctioned to the AEGIS. AEGIS. There is nothing criminality about this. I'm not. Then my lord will kindly see exhibit PW exhibit 53 at page 214. This is payment and receipts which were issued, my lord. Either checks. Payment and receipt, my lord, this is what my humble submission is of no use, doesn't indicate any.
Page 24.
Page, page 26. 26 to 34. 26 to.
Page 26 is demand promissory note, part of.
Hello?
It's a part of demand promissory note.
Yes, page 23, if you're operating C, it is 51.
Page 23 is 51.
So it's part of sanction letter. Sanction letter is 51. Which I placed 51.
No, page 23 is an independent document.
All right. So this is a payment, my lord. This is a
No.
demand promissory note.
Huh.
Demand promissory note. This is, my lord, to the bank, because that's how it is associated with it. I promised to pay Imphal Urban Cooperative Bank. They obtain, my lord, when they disburse loan. Then next is, my lord, payments made. Taken out and made. Then these are, my lord, from, this is Caesar memo, WU. Then payment and receipts, my lord, will find at page 27 onwards. 27 to 34. 34. And the deposit slips are there. Then receipts in cash, current account. All they have all seen it from bank. From the account of AEGIS. Then the checks which were issued, they are exhibit 54. Exhibit 54 at page
And the
30.
transactions are interesting.
Hello?
The transactions are interesting.
Yes.
I'll tell you why. Page 22, 50 lakh was sanctioned.
Yes.
Out of this 50 lakh rupees, you give all the documents. At page 24, they take from you 25 plus 20,
65,
45
65 lakh.
as security.
That's good.
Not 65, this is 25 plus 20, 45.
Then another more.
Oh.
There were
So
three.
45 out of loan of 50, 45 lakh they retain by way of fixed deposit.
Those were term deposits, so say deposit is with us. So we were term deposits, already existed and it was in the bank. Later on, what happened? They encashed it. They paid the whole amount of, returned whole amount of 50 lakh by encashing the term deposit. Because they are necessarily paying, keeping with them and paying extra interest, so they have paid it. Now that has been taken as a big ground for it. What they say, you've taken 50 lakh and returned in 14 days only. And they don't read the subsequent statement of the bank that this was by liquidating by deposit, by term deposit, liquidating the term deposits
Okay.
and cashing this. I will show you evidence. It is there. Everything is interested. Then, my lord, your lordship will see page 35. It's exhibit 54. Exhibit 54 is from 35 to 39. These are all checks. All checks. I don't know what they want to show. These are all in black and white, audited. Then, my lord, exhibit 55 series, which they have obtained from my chartered accountant's office, which I give, my lord, for auditing and for further filing returns. At from page 40 to 55. Chartered accountant is also a witness, my lord, here in this case. Page 40 to 55. D.K. Bohra and Company is a chartered accountant. Then your lordship will come to page 56, exhibit 56. This is utilization certificate. Utilization certificate,
Page.
page 56. Utilization certificate, I'm sorry, is at page 63. Your lordship will come to 56.
56 production.
Then your lordship will go to 58. This is what was produced. This is a statement of account from 1st April 2007 to 31st March 2008. And nothing is just below the receipt and payment of account in the box. 2008. So this is a statement of account which they have collected from DK Bora and Company, Chartered Accountant. Now, my lord, will come to utilization certificate, which will, according to me, is an important part. 56.
But here's page 58 is an entry which can link.
Yes, yes.
At the top, page 58 is receipts.
And what they say is,
1, 2, 3, 4, 5th.
yes.
Unsecured loan from friends and relatives.
Yes,
Say if it's a corporate, juristic person,
Yes.
they can't be a friend and relative. So this friend is someone,
that there is some entry. There is some entry, my lord. I'm just asking a question myself. Have not seen a balance sheet, audited balance sheet where auditors do not object. The auditor objects. But that will not make it criminal. It maybe, suppose a wrong entry is given. There are different department to take care. Because they have said about this, there is no proper documentation. But that will not, they will not jump to the conclusion this is extorted money since you could not explain therefore this is an extorted money. So tomorrow they will raid my house and say this is 50,000, you have not accounted for, this is an extorted money. And that will be different. Kindly come to 63. Here your lordship will get an idea of what this society is. Utilization certificate and issued by DK Bora and Company, same chartered. 35, page 63.
yes.
35 that out of 28 lakh 9,000 as financial assistance from MM4 of Horticulture Technology Mission as first installment for Ministry of Food Processing Industry, Government of India. Released during the financial year 2006-2007. Released during the financial 2006-2007 in favor of Messrs Association for Extensive Grower Innovative Service, adjacent to RIMS Road Corner in Park, Manipur, given in the margin and rupees nil on account of unspent balance of the previous year. A sum of rupees 28,09,000 has been utilized for the purpose of agri-business project for setting up pineapple processing cold storage plant at Matai so and so for which it was sanctioned, and that the balance rupees nil remaining unutilized at the end of the period year has been surrendered to so and so it will be adjusted. This shows, my lord, that this society was getting a regular contribution from Government of India. Lord, I just did a case before single judge, Narani Traders. Their transport subsidy was there. The lordship knows the normal objection is, no, these are all fraud. The sales tax is inquiring into the matter, so many things. I showed to the court that there are check and balance in whatever central government does. Any scheme by which money is granted to someone, there is a scheme. And officers from central, from state, all are involved at different level as a check and balance. So by saying somebody, suppose my lord be an officer of the sales tax department says, you give me, you are getting a 1 crore, give me 50 lakhs or give me 20 lakhs, I will pass it. I don't pay. He puts an objection. It is held up. Same thing had happened in Narayani. They have stopped their single judge has passed, my lord, that, and the payment is also made. They did not even file an appeal before division bench. Payment is made. And this recently, this last year I did that. So here what I'm trying to say, when central government is giving money, central government has IB there, especially in Manipur, which is disturbed area. There are subsidiary intelligence bureau, SIB. They are the one who will immediately stop this, that look, this is in front of so-and-so organization and you are funding them. At least they could have inquired into the matter. They have not done. Now, emails that they have relied upon, if my lords will remember, A18 I referred in while ongoing A6.
You remember, I'm not naming the Prime Minister came to Kohima.
Oh, yes, yes.
And who did this? Who gave the security? I did not say anything more.
Yes.
You know it, Mr. Chaudhary? No. Yeah, ask him privately.
Justice Jalve Angami was a friend of mine. He joined as APP. I joined as Commission in 1976. He was 2 months senior to me.
Yeah, just a moment.
Uh, He was
Yes,
from,
sir.
I just want to know your lordship remembers, there were two disclosure statements, one by accused number 18, the other by accused number 19. So I only referred accused number 18 because it was relevant to accused number 6. The emails which are relevant to this accused number 24 are disclosed by A19. And I'll take your lordships through the disclosure memo. That is, your lordship will find at page 95, capital A of the compilation one. Compilation one.
Compilation 1.
Yes.
95.
Yes, sir. I'll just read out the 3 lines which are important. Second paragraph. I am a member of UNLF since 1967 and presently the chairman of UNLF. This will not go in 27 recovery manner. I used to send and receive details UNF activity through my mails ID, Salaitare, Enterprise VK, Pathfinder. So these are the 3 emails which this person was allegedly using. Now, your lordship will come to the recovery memo at page 96. Recovery memo is dated 11/12/2010, page 96. Compilation 1. My lord, 9th line from the bottom. On getting access to NIA office computer, he tried to open his email, that is email ID, that is Enterprise DK, by entering his password, so and so. Finally, the password led to opening of the email, and the email ID Salai Tare was opened by entering password so and so. So 2 were opened, Enterprise DK and Salai Tare. Then 3rd email, Pathfinder, was tried by the accused to open by typing his words. Since these email ID were not opened for more than 21 days, email could not be accessed to. So out of 3 mailers, 2 were opened, 1 could not be opened. Now let us see print out how How can it be, from which email the printouts were taken? The next page. Thereafter, page 97. Thereafter, the accused was asked to open the email available in the inbox, email sent to the others, as well as email available in the draft and so on. The printout, your lordship can be marked, the printout of each of the email enterprise DK sent, received, and available in the draft, junk, and others taken. Some password protected files were opened, and the passwords as mentioned below by the accused, his password so and so. So printout from enterprise DK was taken, that is there. Who has taken it, that is not shown. Then, my lord, the third, after quotation, the second paragraph, the printouts were numbered serial number 1 to 0, not there, nil. And were signed by aforementioned independent witnesses. The printout of the emails reiterate were not taken as witness was getting late. However, request for printout of this mail ID will be made to forensic expert. I'm reading further. Shiva Prasad Mohanty, network administrator of NIA, was provided with a sterile hard disk in sealed with mark so-and-so, bearing seal number so-and-so, and requested to check whether it contains any data, virus, trojan, or any other defect. Shiva Prasad Mohanty opened the seal of the hard disk in presence of independent witness and confirmed that it is sterile and does not contain any virus of any other malware, is in good condition. Shiva Prasad Mohanty was requested to transfer the data available in the aforementioned mail opened by the accused in the custody R.K. Meghan to the available hard disk. According to Shiva Prasad Mohanty, transfer the contents of these mail to hard disk. These hard disks were wrapped in a piece of white cloth, sealed with NIA seal. The impression of NIA seal were taken in the ink and lac, and perhaps were signed, and papers were signed by the aforementioned independent witnesses and accused in custody. The sealed hard disk was also signed by the independent witnesses, accused, as well as the team member of NIA. After sealing the hard disk, the NIA seal was handed over to Sudesh Kumar Sharma, independent witness, for safe custody. After transferring the contents of email opened by the accused in custody, was asked to sign. So this is only Enterprise DK, they have taken the printout. But this was also not exhibited by any person from NIA. Not exhibited. Rather, it was taken in a sterile disk and sent to CSF Chandigarh. And it is they who took the printout. Page 99 is the certificate. I have placed it yesterday. With regard to the email of R.K. Meghan, page 99. Yeah, it underlines it. I have taken your lordship may see 99. 99. Certificate under 65B. It doesn't even say 65B4. I, Shiva Prasad Mohanty, Network Administration, IT Wing of NIA Headquarters, Splendor Forum, New Delhi, do hereby certify that the computer installed at NIA office at New Delhi, from where the data retrieved from email on the disclosure of the accused R.K. Meghan, he is accused 90, in police custody, is under my technical control and supervision. I further certify that process of downloading the above email was interrupted. Same thing as PW 53. Now, therefore, these emails were not exhibited by anyone from NIA office, and they say that printout were taken, but they just kept it. It is not exhibited. Now, the printouts were
Those printouts were
Yes,
printed elsewhere.
Chandigarh.
Those were exhibited.
Yes. Yes, in some of the emails which I have, I'll show their seal is also there. In original, all this, they are seal. CISF. Up to 30 we are not concerned. Now, my lord, your lordship may just take a note. I placed it yesterday. PW 5. He is M. Bhaskar. He, at that relevant time, he was Junior Scientific Officer, CSF, Chandigarh. He exhibited 2 to 30. He exhibited, my lord, 2 to 30. Your lordship may have the compilation, your lordship will remember it.
Page.
3. My lord, page is 34 of compilation 3. I placed it, my lord, yesterday.
It's very difficult to remember at times.
You know, so many cases you are doing. How can you remember? Page 34. Doctor C. 34. Is PW5 M. Bhaskar. From here only your lordship shows 600 cases. Second paragraph.
Now, yes, now I'll remember.
Yes. And the third para will be relevant thereafter. In the instant case, CFSI Laboratory Delhi, Chandigarh received 2 sealed closed parcel sealed with seal impression corresponding to a specimen signature, seal impression forwarded
Yes,
by
yes.
NIA.
I remember.
Now, he is the person at page 36.
Yes.
Exhibit 2 to 30. 30, your lordship will find at page 38. So 2 to 30, we are not concerned with this. But in any view of the matter, there is no certification. So for whomever it is relevant, there is no certification under 65B. Huh. Right. Yeah. But for this witness, the emails which are relevant would be exhibit 190 to 196. 190 to 196. I'll just say what it contains, because it is not in evidence. It cannot go into evidence by no stretch of reasoning. It can go into evidence. Therefore, I will simply place what it contains. Exhibit 19, if your lordship will take up combination 1, is at page 114. The combination 1. Page 114, contains. To refer 3 more witnesses, my love, I mean. Now, this is a staff pattern of the AEG. Your lordship will see below this is Chandigarh, the left side. Filled by Chandigarh. This is very faded copy that we have got.
Okay, we can't read that.
Now. Then next page, you know, people see at page 115. On the left side, junior scientific officer, central forensic. And these are all executed by them. They're printed there and executed by their officers, CFSL,
Oh, yes, Chandigarh.
Chandigarh. Then, my lord. But what they are saying is that these were recovered in email, these were in the email and attachment recovered as the statement disclosure made by A19, therefore there is connection. Therefore, it belongs to them. They are investing extra treatment. So the whole thing is based on this. If there was a certificate, I would have gone detailed and argued it. But if there is no certificate, therefore I will just touch these. So exhibit 190 is a staff pattern of AEGS. That 191 is meeting of AEGS. They have got copy of what happened in one of the AEGS meeting. That was, according to them, was recovered in the email. Another one is, my lord, 192, which says AEGIS is interested in Tetra Packing. So these are the things which they have got, and then they have imagined that since they have all this, they are running there, it belongs to them, it's their trust. I will just give my lord the page number. Exhibit 190 is page 114 of compilation 1.
Exhibit 190.
190
Yes.
is at, this is contained staff pattern, according to me, of AEGIS at page 114, compilation 1. 191 is meeting of AEGS, copy of that, at page 118, compilation 1. 192. 192 is AEGIS interest in Tetra Packing at page 121 of Comp 1 minute, compilation 1. Then there's two, my lord, exhibits which were not there. We have been closed in compilation 4. My lord, compilation 4. At page 193 is at page 1 of compilation 4.
Page
1. And 194 is at page 13 of compilation 4.
page 13, 13.
1 of compilation 1. 4, sorry.
Compilation 4.
And 195 is at page 14 of compilation 4. One 196 is at 15 of compilation 4. So these are the emails which have been relied upon. And these compilations were exhibited by PW 44. And I'll place this.
Compilations means those exhibits 194, 190 to 196.
Yes.
Proved by PW.
PW 44, DP Gangwar. He is at page 52 of compilation 4, DP Gangwar.
Page 52 compilation.
4, 3. He was junior scientific officer at that point of time in CFSF. And he had to be re-examined to bring these on record. At page 55, my lord. In continuation of my earlier statement, I further state that on 10/2/2014, I had appeared in this court and deposed in this case. On 11/11/2011, I received one DVR Moser Bayer bearing so and so for providing hard copy, Your Lordship kindly see, for providing hard copy of the data present in the DVD. Accordingly, I had examined DVD R in the laboratory and it was found to be DVD containing so and so. Then Your Lordship will see the soft copy of the email contained has been provided in one DVD. The hard copy was also provided with report which bear my signature. Then exhibit 190 to 195 he has mentioned. Now there are, apart from this,
This is again a query. Please come to page 55. Again, this comparison. 3. Third line. I received one DVD-R Moser Bayer bearing capacity so and so with reference so and so. Accordingly, I had examined DVD-R in the lab and it was found that DVD-R containing 3 folders of so and so. A soft copy of this has been provided in one DVD and the hard copy was also provided with report bear my signature. Now, The further examination is different.
Yes.
Now,
The next page, he talks about photographs.
no, now he says about these exhibits marked as marked as so and so.
Yeah, that's
Now, where is the evidence of that DVD? DVD itself has not been proved.
not, has not been proved. Has not been proved. If it has not been proved, but even if it is proved, my lord, what does it make a difference? In
No, it does.
65B4.
No, it does. You see, 65(4) certificate is something else.
Yes.
But from the original computer, what would be a document? It would be the first transfer made.
Secondary evidence.
So,
But then if it is transferred, my lord, that itself cannot be proved.
no, that is second part.
Yes.
First part is that the
Yeah, it
what is
not there.
it's a CD which has been transferred. So for CD, there is no certificate.
It's
From
not
that
there.
certificate, printout is made, and even in the printout, that certificate you say is for printing is not there.
It's correct, that he will reply. Yes.
I'm just trying to understand your facts. DVD is not exhibited.
No, not to our knowledge. If he has hidden somewhere, he can. Not to our knowledge, we have checked. Without-
Mr. Das, you've got the query? You've got the query? You see, from the computer, copy is made in a DVD. The DVD doesn't appear to be exhibited. That is what the question I am posing to Mr. Mishra. So you'll have to address us on that also. Because what is a document? Electronic transfer is also a document. And for that a printout. So therefore, there should be two certificates. Number one, DVD proved, DVD certificate. Printout proved, printout certificate. That is what I am understanding. So you'll have to address us on that also.
But can there be secondary evidence of secondary evidence?
No, it's a printout. Printout is permissible under the.
Printout is a secondary evidence.
Huh.
Suppose the computer is under my charge, I print out from computer. That will be secondary evidence, because if you lordship will see the facts of Bashir case, in Bashir case, DVD was played and an FIR was filed on that DVD. What they did, this DVD they took and they put it in computer and make copies from there, and that copies were produced and that was negated. I have not, subject to law, I don't know where it's mentioned, but there cannot be a secondary evidence of secondary evidence. This is off the record, I mean, it is just off the cuff, I'm thinking. There are three witnesses I have to submit and they have prior post this.
No, because 3:30 will have to rise. Single bench. And my brother is a parted matter again. Single bench.
3:30. I'll finish in 2 minutes.
Huh.
Otherwise, I'll leave it to your lordship. Okay. So, well, first 43 I want to refer at compilation 4.
If you leave it to me, I'm happy because I'm known for dismissal.
I know one thing, that what you said that you may be doing in criminal cases, but I know that I leave it to your lordship if I cannot come.
Yes, yes.
3, compilation 4. We'll come to page 28, just 2 lines. He was the president at the relevant time, who had been made a witness. He's a retired government servant.
Page.
Page 28. 28. I'll read 2 lines at page 22. I worked, my lord, got it?
Yes.
I worked as Director Agriculture, Government of Manipur. I retired in the year 2000. After my retirement, I joined a private firm called AEDIS, is a registered society. Then your lordship will see, for my purpose, next page. Next page. And he joined as the president, and that also not clear in the cross-examination, unfortunately. But from here, your lordship may gather it. At page 29, first paragraph. During 2005, I came to Guwahati to meet the consultant of the project in connection with GIS. It was a discussion where I met Secretary N. Bhumi Singh, brother Vidhu Singh, Ebonta Singh, and some other, which I do not remember, because which I do not remember. There, the person whom I met was known to me, but he asked regarding viability of project, which I replied, it's going well. After my return to Imphal, I continued as president. So he joined as a president after his retirement, and in 2005, he says he's continuing. He has been made a witness. He is head of the governing body. He's a witness. Now, my lord, I'll come to the evidence of three persons which have been relied upon by the trial judge. PW 23, 24, and 43 have already placed. Nothing more to place. Only two more left. 23. 23, your lordship will get at page 21 of the same compilation. 21.
21.
The same compilation 4. He is, my lord, the general manager of Imphal Urban Cooperative Bank. I have been working with, may I read, my lord, at page?
Yes.
I have been working with Imphal Urban Cooperative Bank. I retired as general manager of the bank in 2011. During that period, I have been working in the bank in different capacities. As Association of Extensive Rural Innovation Service is a registered firm of Imphal having accounts in our bank. Exhibit 48 is the application of the secretary. I just have already taken your office through to the branch manager of the bank for opening account along with the said application. These are not required. The last paragraph on this page. The AEIG applied for loan of 50 lakhs, which was sanctioned by bank on 3/7/2005. 3 term deposits of which the party submitted into bank 25, 20, and 20. This is what makes 65 lakhs. For securing the loan, the party thereafter repaid the full amount on 16/8/2005. The learned trial judge only read up to this. Rest he has just ignored. Or it may not have come to his mind. By adjustment of term deposit within 14 days. Exhibit 50 is the loan account statement from 37/2005 to 6/8/2005. Exhibit 5 is the loan section, etc., etc. Then, my lord, I will come, then paying slip and all not concerned. I come to the cross-examination. At the time of loan transactions, which I mentioned in my examination in chief, I was not administrative office. I was not at the administrative office of the bank. I was working manager, Lamlong branch of the bank. One so-and-so Singh was general manager of the bank at that time. He said so-and-so Singh died about 1 year back. He suffered from cancer. All the accounts and transactions of the bank, might have kindly marked it. All the accounts and transactions of the banks are audited by and inspected by the Reserve Bank of India and the state auditor of the state government. There was adverse comment from the auditor, including that of RBI as regards above mentioned loan transaction. I produced the document exhibited during my examination in chief to the investigating officer as outside after I took charge of the bank as general manager. I have no personal involvement in the said transactions. The nature of transaction of the said loan and sanction so-and-so, coding so-and-so by adjustment of term deposit is permissible within the norms of the bank. Why Brother Vidhu and Bhumi Singh, I Bhumcha Singh are good customer of our bank, a certificate not required to be read. Now, what my lord the learned learned trial judge said was this. Kindly see at page 54 of the judgment, my lord. Part 1, volume 5, paragraph 54. It's at 974. Part 1, Volume 5.
Page,
Page 974. Now, in this, my lord, the trial judge is referring to PW 23 and three lines from the below, your lordship will see. The fact of taking huge amount, that is 50 lakhs, he has said above, huge amount of loan, a repayment of the same within such a short period was really unusual. Spoke loudly about the extreme financial soundness of the firm. Financial soundness of the firm per se cannot be held to be an offense if legal sources of the money is visible. But this is not the case. Only this I will read from here. He says something else. If the loan was taken by deposit of term deposit and it was encashed and paid, he is drawing adverse conclusion, my lord, adverse inference. Then, my lord, the last witness which I will place is PW 24, my lord. 23 is over, PW 24. PW 24 is page 23 of compilation 4. Page 23, compilation 4. My lord, this is my lord, seventh line from third para, seventh line from the top, my lord. The accountant after production, your lordship has seen. Third line, third paragraph starts with among the clients. I am reading the seventh line from below, my lord. The accountant after production used to take back the books of accounts and other documents. Your lordship got it. I found that some of the contributions were not supported by proper documents. My lord, kindly see this. I found that some contributions were not supported by proper documents. He is the chartered accountant. And I advise the said transaction should be through bank with proper receipt and should be supported by the bank statement. I also noticed that there were loans of bigger amounts taken by the firm, but I found that the bank statement do not reflect the repayment of the loan. After my advice, AEGS did not come to office and then they cannot say how they manage the firm. There were other chartered accountants of the firm. Now, what the trial judge has written, I've just left, my lord. I placed paragraph 54 at page 974 to continue where I had left. Page 54, paragraph 54 at 974. 974. I'll start last line. Financial soundness per se cannot be held to be an offense if legal source of such money is clearly visible. But that was not the case. It would be evident from the testimony of PW 24 CA. I've just read out, who was chartered accountant and was given the task to audit balance sheet of AEGS at the relevant time. He deposed that the firms produced bank accounts of audit and A23 came to office. The witness further stated that large amount of contribution was not supported by any document. Whereas what he said is some contributions are not supported. Very large amount of contribution. So this is how the evidence has been made. And
Mr. Mishra will have to rise because
Yes, yes. No,
Yes, sir.
I have-
whether is a partner matter through video conferencing from Kohima,
I'm very sorry. Yes, yes.
from
Yes, sir.
Kohima.
So
So,
far as I'm concerned, I have completed. If there is anything left, I'll cover it up in my reply. I take this liberty to ask.
okay.
So now I'll come only after this.
Will it continue tomorrow?
No,
After.
just a moment. What we can continue? Mm. Just repeat the last order. Last order is there, same order. Mr. Mishra, remains inconclusive. No, sorry, the submission of Mr. D.K. Mishra, Senior Counsel, for the appellants in so and so is concluded, reserving right to reply. Mr. Also right there, assisted by Mr. B. Prasad. The Mr. D. K. Das, Senior Counsel, assisted by Ms. P.K. Darji, Counsel for the respondent number 1, and Mr. R.K.D. Chaudhary, learned DSGI for respondent number 2 are present. List on tomorrow as a part and pattern.
Can it be taken up day after tomorrow, Lord? Because for the remaining appellants, we can see he appears, MCC. So tomorrow he will not be available. In some personal problem, he has to follow.
Oh, yes.
Yesterday he mentioned it before him also. So can you rectify tomorrow meeting? So can
We'll
you-
complete their part and then start yours.
What can reply or Lavish concepts?
No, there are continuous appeals.
Yeah.
In the Mr. Mishra's cases, you want to reply it earlier or you want his part to be over, then reply.
It will be better if they.
If they do it, then it goes after 3 days. Then we'll have it. We can next have it on 15th. 15th of February. 15th. This is part is present. List
The rest of the.
as a part of matter on 15 to 2024. I'll be traveling.
With lordship's permission, Madam, item number 8, Madam. Can it be fixed on a date, Madam, or next week, Madam? Maybe on 16?
For correction of typographical error, which is kept in paragraph 7 of the order dated 4/1/2023. Full stop. It is submitted by the learned counsel for the applicant that instead of word disposing, the petitioners, inverted commas, page 20. Disposing the petitioners from their patta land without due process of law. You just said. It said that the typographical course and so and so, paragraph 7 of the said order is quoted below. It is pointed out that the word disposing, disposing, inverted commas, DISPOSING, disposing, appearing therein is an incorrect word and it should have been, the correct word should have been dispossessing. DISPOSSESSING. Full stop. Next part, the Leonard cost for the opposite party number. Uh, TN. TN. 3 and 5. Has no objection to this. To the prayer. Next, accordingly, you are also there, Mr. Handick. And Mr. J. Handick and Stanley Cosmo for response number 1. Have no objection to this prayer, to the prayer made. It also appears that the word is incorrectly typed. Full stop. Accordingly, this application stands allowed, and the word disposing appearing in paragraph 7 should now be read as dispossessing. Full stop. This order shall be read together with order dated 12/1, order dated 4/1/2023, passed by this court in WPC 8416 of 2022. Okay. The That's all.